Good morning, everybody. I'm Jerry Roth, the president of the UIA. I welcome you, and I'm delighted to have you here for a fascinating webinar this, I say morning because I'm here in California, afternoon in Europe, on new trends and best practices in taxation after COVID-19. I will introduce our moderator in one moment, but I just want to remind everybody, as you all know, UIA gathers over 2 million lawyers through its individual and bar association members. We're the oldest international association of lawyers, founded in 1927 in Belgium, and now with our main offices in Paris. We cover a vast array of international legal issues, as well as defending lawyers around the world in their pursuit of human rights. And we have been extremely active during this COVID period, which has been obviously very difficult for all members of our profession and all of our society more generally. We have webinars like this one, podcasts, videos, various website locations of collections of documents, and we're now preparing for, we're very excited to be preparing for our virtual Congress, which will take place on October 28th through 30th. The theme of it is three days around the legal world, and we will be traversing the globe with presentations from here in San Francisco all the way around the globe to Japan, China, Hong Kong, and everything in between. So thank you all for being here this morning. I really appreciate it. And with that, I'm going to turn the microphone over to my friend Martí ADROER in Barcelona. And I will click off my mic and my camera so as not to be a distraction. And I wish you a wonderful seminar. Thank you, Martí, and thank all of you.
Thank you very much, President Roth, for this introduction. Good morning, afternoon, or evening to everybody, depending on what part of the world you are connecting from. A very warm welcome to all of you, although for obvious reasons, it has to be a virtual welcome. Many thanks for joining this seminar or this webinar on new trends and best practices in taxation after COVID-19. I am very pleased to introduce to you the agenda that we have for today and the speakers. We have prepared 6 bills of 10 minutes of duration each, more or less, on hot tax topics related to the post-COVID-19 situation. And we will have a Q&A session at the end of all the presentations. So in order to better organize our time, we will deal with all your questions at the end of the seminar. However, you can send your questions whenever you want. You can post your questions in the chat of the seminar, and we will deal with all these questions at the end of the presentations. Well, these are the speakers that we have for today. First of all, I will be giving you a brief introduction or a brief update on the negotiation to the taxation of digitalized economy. By the way, my name is Martí ADROER. I'm a tax partner at the Spanish and Portuguese law firm Cuatrecasas. After this topic, Riccardo Cajola, a partner at Cajola and Associati in Milan, Italy, will talk about some transfer pricing considerations which are relevant for multinational enterprises in light of the COVID-19 pandemic. Alexander PUPETER, partner at Blomberg in Germany, will follow to talk about the introduction of tax breaks to increase current liquidity of businesses by deferring the tax burden into the future. After Alexander, Łukasz Kwiecinski from the Polish law firm WKV will elaborate on measures aimed at relaxing the collection of taxes to help liquidity of companies and give a little bit of relief to the impact of the COVID-19 crisis. This will be followed by a presentation by Daniel LEHMANN, a tax partner at the Swiss law firm Baer and Carrer, that will focus on tax issues associated with the recapitalization of companies. And finally, Marilyn McKEEVER from New Quadrant Partners Limited in London will tell us about the impact of COVID-19 on the administration of justice. We trust you will find all these topics interesting enough to stay tuned throughout the whole session. And I want to thank all the panelists for being with us today. And with no further ado, I will start to present the first topic of the webinar, which, as I mentioned, intends to briefly update you on the current situation of the negotiations on taxation of digital businesses. I need to go to my presentation here. Okay, this is the topic I will cover, Quo Vadis taxation of digitalized economy. We will cover these topics, and now we can go directly. Okay, here we go. When it comes to taxation of digital businesses, the first question one must ask is whether there is a real case for a tax reform. And to answer this question, we have to analyze what type of business models do we have today. What is very clear is that business models have changed dramatically over the last 2 decades. Actually, we have witnessed how businesses have transitioned from, let's say, a brick and mortar economy to a completely digitalized economy. The COVID-19 pandemic has further accelerated this process. It is very obvious that this pandemic has introduced significant changes in consumption patterns, very relevant increase in the use of digital services. We don't go to the cinema anymore, but we watch Netflix or these platforms, etc. So the result probably from the pandemic for these type of businesses is that they will be reinforced after the crisis. Their position will be reinforced after the crisis. So what are the main features of these digitalized business models? It is important that we understand these features to understand how the current international tax system is failing to capture part of its revenues. Well, the main feature is that no physical presence is required anymore to offer goods and services worldwide. Actually, a very significant activity can be carried out remotely with very little substance or no substance at all. There is an ever-increasing value of intangible assets. Most of these business models, the added value, it's in the intellectual property or intangible assets that they have. Another feature is that these businesses can obtain huge economies of scale without significant physical presence. And finally, there is a new element, which is that customers contribute to value creation for the companies when they transfer data to these companies. We all know that nowadays data is the new gold. So this element of the role of customers in value creation is also very important. If we compare the main features of digital businesses to the main feature of the current international tax system, we will identify significant differences. Actually, I think that we should say significant mismatches between the two worlds. Well, the current international tax system actually has its origins in the League of Nations. So this is over a century ago. The current rules were formulated where physical presence was probably the normal or probably the only way of doing business abroad or even in your own country. Based on these rules, established that taxing power on income was traditionally required physical presence in a country. If you did not have physical presence in a country, your income would not be taxed in that source country, but would be taxed only in your residence country. Well, this tax consensus that actually is contained in the OECD Model Tax Convention has remained like this for, as I said, for more than a century, but is now being challenged as market countries. So those countries where consumers buy these goods or these services claim their fair share of tax. The OECD, the European Union, and other players hold that a significant economic presence should be enough to be treated as a new nexus rule, so a new point of connection with the jurisdiction, and that the jurisdiction of the client should have the right to get part of the taxes of the company. It is important to point out that these reflections do not only apply to the so-called tech giants, because this is not a discussion about digital economy or digital businesses, but of digitalized economy. Because, as for instance, as the OECD has pointed out, it doesn't make sense anymore to talk about the digital economy, but we should talk about the digitalized economy as the whole economy has gone digital and will go digital. So any measure that aims at ring-fencing a specific sector, a specific companies, is called to fail in the future as the whole economy gets digital. Well, as you can imagine, this discussion about shifting taxing power from one jurisdiction to another unavoidably leads to significant economic and political conflict, as we will see later on. So, how to tax the digitalized economy in the future? Here, there is like a trade-off. There is a tension between trying to find a long-term solution or either to implement interim measures. Obviously, the ideal solution would be to find a long-term solution, which would be a global solution, multilateral, consensus-based solution, that this would actually imply a fully fledged international tax reform. This, as I said, would be the ideal thing to achieve, but as you can imagine, it is very difficult to achieve from a political and economic perspective. On the other hand, if this global solution is not achieved, what countries may be tempted to apply is compensatory unilateral taxes for digital businesses. Usually this is presented as an interim measure that countries are ready to apply until a long-term solution is reached. When it comes to finding a long-term solution, a global solution for taxation of the digitalized economy, there are mainly four approaches. One approach is user participation or market approach. This is supported by some of the European countries. This would give more significant weight to the market where the users are. There is the marketing intangible approach. This obviously gives preference to the place where the marketing, the intangible, are located. This has the US preference. It's not a surprise, as most of the most relevant digital companies are headquartered in the US, and this is where they have the intangible assets. And there is a third approach, which is basically to understand that one should identify whether there is a significant economic or digital presence approach. This, for instance, has the support of the G24 countries. And finally, there is a fourth approach, which is actually, we can call that it's a unified approach, which is a kind of compromise solution of the other three approaches. This is the approach endorsed by the OECD. This is the so-called Pillar 1. Probably many of you have heard of this. But this Pillar 1 would introduce a series of changes in the international tax system that would affect fundamental principles of this international taxation, such as the physical presence nexus and the arm's length principle. So, as you can see, in this picture, we have different players trying to put pressure in the direction of the interest of the countries. So, what is the current backdrop for all these negotiations? Well, first of all, it is important to take into account that the OECD, through its inclusive framework, which includes more than 130 jurisdictions, has been working on a multilateral consensus-based solution since 2018. The European Union also made a couple of proposals. One was a digital service tax that was presented again as an interim measure, and the other one was a digital permanent establishment concept. This aimed at being a long-term solution. Actually, both proposals failed in March 2019 when they did not receive enough support from member states. So the situation that we have now is that the mandate that the G20 gave to the OECD to deliver a solution by the end of 2020 is still there, and the OECD is committed to meet this deadline. An important development was January this year, when the inclusive framework of the OECD met, and they issued a communique where they reinforced the commitment to achieve a multilateral solution. It is important to point out that in this communique, all the countries in the inclusive framework accepted the idea of analyzing a proposal by the US to consider a Pillar 1 as a safe harbor. So not as a compulsory rule, but as a safe harbor that countries or tax administration could use. However, this was obviously before the COVID-19 pandemic started. Quite recently, actually June this year, the US Secretary of Treasury sent a letter to 4 OECD finance ministers urging the OECD to defer discussions on Pillar 1. And basically, the Treasury Secretary said that governments now should focus their attention on dealing with the economic issues resulting from COVID-19 and set aside discussions about how multinational enterprises have to be taxed in the future. This letter got an immediate reply by these ministers, where basically they took the opposite, exactly the opposite position, saying that precisely because of the changes that COVID-19 has introduced in the behavior of consumers, the use of digital services, and as we already pointed out, that as a result of this crisis, digital businesses will come out reinforced of this crisis. They stressed the idea that it was particularly important not to postpone the negotiations and try to find this multilateral solution. Actually, immediately after this letter, the OECD Secretary General stressed again the need to find a multilateral solution based on the work already carried out by the OECD if proliferation of unilateral measures, tax disputes, and a trade war want to be avoided. Although the OECD Secretary said this, the truth is that in the meantime, as many as 30 countries, and actually this figure may be a little bit outdated, have already introduced or are in the process of introducing unilateral taxes to tax digital services. So you see that the strategy of the countries is that while all this discussion is taking place at the OECD level, at the individual level, they are taking steps to have legislation in place to tax unilaterally this section. So as you can see, I mean, now we are in this impasse situation. So this is a situation that a story that will have to be continued. We'll see whether finally countries reach multilateral agreement, or otherwise they will go for unilateral measures. There is obviously a high political tension here because, as you can imagine, as a result of the COVID crisis, now countries, or many countries, will run significant fiscal deficits because tax revenues have gone down, social expenditure has gone up, so they have larger fiscal deficit, and they are eager to get money. So chances are that if there is no multilateral solution, we can see a proliferation of unilateral measures, and then we'll see what the reaction of countries like the US is. Here you have a Twitter by President Donald Trump where he threatened with a tariff war if France imposed this digital tax, as President Trump considers that these unilateral digital service taxes are a direct attack on US tech giants. So unfortunately, we do not have the solution of this very thrilling battle, but probably we will see very significant developments by the end of the year. So this is what I wanted to share with you in this first spiel. Now we will move to Riccardo, who will cover some transfer pricing issues that affect multinationals in light of COVID-19. The floor is yours, Riccardo.
Thank you, Martí. Italy is one of the countries who has adopted an interim measure, so I strongly hope that Mr. Trump, President Trump, will not threaten us as well. But anyway, let's come to my topic. It's about, as Martí anticipated, is about COVID impact on transfer pricing. As we know, pandemic outbreak is hitting economies worldwide, and containment measures are limiting activities, disrupting global supply chains, and increasing uncertainty in financial markets. Because of that, multinational enterprises are experiencing significant decrease in global sales, in capacity utilization, and extraordinary costs to operate business during lockdown. And this is resulting in a profitability reduction in operating losses, very likely for many companies this year. As a consequence, multinational enterprises shall consider the impact on their transfer pricing policy, especially on limited risk entities throughout their value chain. And I'm focusing my presentation exactly on this aspect. For example, on toll or contract manufacturers and limited risk distributors. These entities are usually remunerated with guaranteed profit under transfer pricing methods. I don't know if you're familiar, like the transaction net margin method, TNMM. Anyway, for those who are not familiar with this topic, transfer prices refers to the terms condition which so-called associated enterprises agree for their control transactions. Example of these transactions are the provision of management services, supply of goods, and provision of loans. So for multinational enterprises facing the negative impacts of COVID crisis, the question arises as to whether the limited amount of risk this entity typically assume would allow them to bear any recession-related losses under arm's length condition, which means as if the parties were independent from each other. To answer, we need to analyze on one side the OECD local tax law guidelines, offer an overview of the possible action to adjust their benchmark analysis for this year, and third, to analyze the crisis impact on the transfer pricing documentation and on advanced prices agreement. Based on the arm's length principles in transaction between independent enterprises, compensation usually reflects the function that each enterprise is perform, taking into account asset use and risk assumed. So increased risk is generally remunerated by an increase in expected returns. Therefore, the allocation of risk between the parties affects how transaction profits and losses are apportioned under arm's length conditions. So limited risk entities employed by multinational enterprises in their global operation are organized with limited decision-making powers and are protected from the impact of important business risks. For example, market risk, operational, credit risk. So as limited risk entities, they are expected to earn routine profit. However, as multinational enterprises are currently suffering from that sales decrease, The idea that their limited risk entities should earn guaranteed returns even under these negative circumstances can be questioned. Independent comparable enterprises performing functions, assuming risk and employing assets similar to those of the limited risk entities will probably record a considerable reduction in their profit by the end of 2020. This could induce multinational enterprises to compensate them with lower margin than those provided by the original transfer pricing policies, or even to leave such entities at break-even level or in a loss position. Any decision should be anyhow taken with reference to, on one side, the OECD guidelines, and on the other side, the domestic legislation where the limited risk entity operates. The OECD guidelines recognize associated enterprises, like independent ones. They can sustain genuine losses. This could be due, for example, to unfavorable economic condition, like in the present situation. In addition, with reference to the selection of comparable companies to test low-risk functions, which are those performed by these limited risk entities, loss-making transaction can be considered comparable. And this is because the facts characterizing the enterprise and not its financial results should determine its status as a comparable. This is also the Italian jurisprudence affirming that. Clearly, the local tax regulators about it should be checked as well. Based on that, multinational may in principle be allowed to decrease profitability on the limited risk entities to attribute them an amount of losses. However, the analysis of how unrelated parties would actually act under similar circumstances should guide the decision. And this implies the performance of the OECD comparability analysis, which is usually required by many local tax laws. In respect, multinational may incur additional risk due to the emergency. For example, they may be forced to renegotiate contract with suppliers or with clients. And in addition, the transaction economic condition shall be examined as well as the financial impact of local measures adopted to support enterprises. So considering these circumstances, 5 comparability factors should be considered. They are the transactional contractual terms, of course, the functional performance, the asset use and risk assumed by each transaction party, the characteristic of the product transferred and the services provided, the transaction economic circumstances, and the parties' business strategies. The analysis starting point should be the transaction contractual framework. Contracts may provide information on how responsibilities, risks, anticipated outcomes were intended to be allocated at the time the agreement was entered by the parties. Contracts may also contain the force majeure clauses, today mostly debated, with liability exemption if the party required to perform is unable to meet its contractual obligation due to events out of its control or not foreseeable at the time the contract was entered. So force majeure clauses may provide guidance on how to allocate risk between the parties and include a list of events on one side constituting force majeure and on the other side provide remedies like temporary contract suspension, contract renegotiation, contract termination, delivery date extension, or even compensation payment. Entitlement to claim relief from a force majeure event will not only depend upon the contract, but also on the relevant governing laws. National laws and contract practices may treat force majeure differently, so be aware of this. Other transaction comparability factors shall be assessed, and I'm just touching upon them, like the economically significant functions performed, asset use, risk assumed by the parties, and compare them with those characterizing uncontrolled transactions. The analysis should assess whether the limited risk entity performed any action to manage the emergency, whether it assumed any risk arising from those actions, which party managed the risk and had the financial capability to assume them. Operations shall be checked to assess which of them was disrupted and require remedies, for example, optimization of production lines. A limited risk distributor may grant to its clients more favorable purchase conditions, like postponement of payment term, as a response to the current crisis. So the functional analysis should then determine whether independent comparable companies would have taken similar actions under same economic circumstances. If the limited risk entities had a decision control on how to react to the economic downturn and the financial resources to withstand relevant risk, then the risk of losses can be partially shared with the limited risk entity. Where the limited risk entity can shoulder the negative consequences, at least in part, the question will arise as how to adjust the transfer prices by the end of this year with the limited risk entities in order to factor in the effects of the current crisis. The issue is that internal comparables are not available because the most recent data of third comparable companies are published on databases normally at least 12 months after the year closing. And this may force to set 2020 transfer prices based on third parties data reflecting pre-crisis conditions. Such approach can result in a non-arm's length remuneration, as limited risk entities may end up with margins higher than those realized by independent enterprises in similar conditions. So it's a big issue, the lack of reliable 2020 comparable data. And this may be addressed by a number of solutions to increase the comparability degree. They include search strategy criteria division, for example, including loss-making comparables we were talking about, period of analysis amendment, for example, the use of data of listed companies or data concerning previous recession years, and comparables data adjustment using econometric statistical model like regression analysis, but I'm not going to enter into this. As far as the transfer pricing documentation, I can say that if based on the functional economic analysis we talk about, multinational enterprises decide to depart from their standard TP policy, documenting these changes within the transfer pricing documentation is strongly advisable. Documentation should demonstrate the reduced profitability and loss is not attributable to incorrect intercompany prices, rather to extraordinary economic circumstances. Eventually, in terms of advanced prices agreements, taxpayers should also consider the impact of the outbreak on their APAs when they have concluded with tax authorities. APAs negotiated in pre-crisis periods and the financial of the selected comparable companies would most likely not reflect the economic condition affecting markets and enterprises. For these reasons, the transfer pricing policy agree with the tax authorities under the APAs may be no longer at arm's length. The OECD guidelines specify that APAs should provide for the agreement revision for termination when business operations change significantly, when uncontrolled economic circumstances affect reliability of the methodology adopted. Therefore, multinationals should evaluate whether and how their APAs allow amendments due to the changes of the economic condition about the agreement transaction. So to conclude and wrap up in a couple of minutes, multinational enterprises facing current economic downturn should examine their current transfer pricing policies about their limited risk entities and assess whether it requires revision. A legal framework, contractual terms analysis of the intercompany transaction will give a preliminary indication of whether the emergency qualifies as force majeure events and whether any room is available for negotiating terms of the agreement at arm's length. In addition, scrutiny of the function performed, asset use, and risk assumed by the parties, together with the economic circumstances, transaction business strategy analysis will indicate whether limited risk entities are expected at arm's length to bear some of the negative consequences arising from disruption. Where they can shoulder a portion of the negative consequences, the TP policy must be revised by identifying appropriate comparable data to reflect the current economic condition. As no financial data of comparable companies will be available on public databases before the last quarter of 2021, multinational enterprises may consider a number of solutions to increase the comparability between the tested party and the comparable companies. In the absence of any guidance, it is recommended anyhow that any deviation from the transfer pricing policy is well documented. Finally, multinational enterprises should assess the impact on their APAs. An agreement provision shall be examined and an assessment made as to whether making contact with the tax authorities to update their APAs to the current economic condition. And with that, I conclude my presentation. Thank you, Martí.
Okay, thank you very much, Riccardo. We will now move to Alexander, who will tell us about tax breaks to defer taxes and increase liquidity for businesses. Thank you.
Thank you, Martí. There is a list published by the OECD about all the tax measurements around the world in relation to Corona or COVID pandemic, which covers more than 1,000 topics. If you look at that, presumably the most important are topics or issues related with payments, late payments, enforcement, and all that. That will be covered by Łukasz immediately afterwards. Besides that, there are also topics with respect to substantive business tax law. I will talk a little bit about that. And I will not focus on special measurements related to, let's say, restaurants or the healthcare sector, but with measurements which have a bit broader approach and might be more interesting for the whole business world. The first thing you see for a lot of countries are measurements related to loss carryback. That's not only Germany, Korea, New Zealand, United States, Singapore, really around the globe nearly. The basic idea behind that is if you have a gain, let's say last year or 2018, and now you have losses 2020. You still have to pay your taxes for the past, and now you have your losses and bad luck. And so some systems have it and some not. You can carry back your losses. And this possibility will be increased by a lot of states. Even Germany, and we are very anxious about our losses, we increase the possibility from 1 million to 5 million euro, which is very good for a business. That means the immediate tax burden will be reduced. Even you might get back taxes you have paid for the fiscal year 2018 or 2019. This means immediate improvement of your liquidity position. But it's sold always as a big advantage, big direction of the policy. Bear in mind one thing, you pay less taxes at the moment, or you just get taxes back. But in the future, you use all your losses, or a large part. You cannot offset your losses with your gains in 2021, 22, if there are any. That means if you are lucky enough, or your business is lucky enough to strengthen its tax base or its equity by gains in the future, you have the full not covered tax burden on that. So you're a bit restricted from building, let's say, new muscles by having gain in the future. That's a disadvantage of this solution, and we have to bear in mind that all the time. Just beside that, some countries are even improving their rules about loss carry forwards, which is a good thing, but in this case, the countries might consider why they didn't have better rules up front, because for the individual business, it doesn't make a big difference whether it's a problem with a pandemic or just an individual problem. Nevertheless, Daniel will later on talk about a bit tax losses in a bit broader approach. I will refer to another topic, which is very or you see sometimes in business income taxation, that's depreciation. You see some schemes with accelerated depreciation, not only Germany, in Australia, let's say Peru, Singapore. Sometimes it's like in Germany, accelerated depreciation on movable assets. If they are purchased in 2020 or 2021, or they are specified on certain assets like data processing equipments, like in Peru, where you have 50% depreciation. That's the same good and bad thing. You have a lower tax burden now or in 2021, perhaps in consecutive years, but on the long end, you have a higher tax burden because you have a lower depreciation later on. That also means lower tax now, higher tax in the future. Our clients have to bear in mind that effect. That means basically we will have a bit a higher or above average tax burden in the years after recovering from COVID, which is in line presumably with the needs of the states to cover their budget deficits, which has occurred now. Nevertheless, I think this is a quite good rule. Why? Because a lot of companies think spending money now on new investments or not, and you encourage them to do it now and not to wait, let's say, for the year 2022 when everything has cleared. And so it gives us kind of a kickstart into the economy without that the government has to spend money for all the time. It's just by shifting the tax burden, it might give the economy a good kick. Actually, we had that in the 1990s after the wall came down in Germany. It worked. Sometimes it worked too much even. There's a third concept you find sometimes, which is partly taxed, partly subsidized, in particular with research and development. Why that in relation with Corona, you might think. First, I think it's nothing to do with Corona, but that's wrong. If you think, what are business doing in a crisis? They stop spendings. They stop spendings on advertisement, and they stop spendings on research and development. That's, of course, a problem in the future. After economy goes on, you have missed something. And therefore, to give a special input on that way helps the economy or all the business to go after the crisis without a lack of research and new developments. Therefore, it's nothing to do with liquidity, I think, but with not missing any too much things in the crisis. But you might think the easiest way to give the companies, the business, a good help would be just to reduce the income tax rates or the corporate income tax rates. If you look through all the lists, you will see that that's not an idea which is very popular around the world. There are some countries doing that, Chile for small and medium-sized enterprises, Indonesia, Kenya, Romania, Malaysia, Vietnam, but all the big countries are not mentioned there. Obviously, just to reduce tax burden without any ado, that's not going to happen. At least it looks at the moment. That's big points about income taxation. There's one thing I would like to as well: VAT tax reduction. Basically, of course, that's not a business taxation because the VAT is meant to be a burden of the consumer at the very end. But that's not really true, because a lot of businesses, at least small businesses, tend that not to change the prices even if the VAT is reduced for a certain amount of time, because it's not worth to have a new menu or new price lists. And that the effect is that this VAT reduction is not an input for the consumer to consume more, but nevertheless it's a kind of rebate for the businesses for a certain amount of time. And if you think that, let's say, retail business has a margin of roughly 3%, at least in Germany or Europe, and then if they got additional 2% by reducing the VAT, that is close to doubling their margin. That's a good thing, even it's very cumbersome to have all the formalities. But I found by looking at this list, there's a lot of countries having that special areas, restaurants, tourism. Some have it for books or e-books, because during a shutdown, people have to be entertained at home, which is very reasonable, I think. But as a whole concept to reduce the VAT, I found it only in Germany. And by the way, I found a VAT increase in Saudi Arabia, which is a bit strange in relation with COVID, but nevertheless it is. That's the most important thing which are under development at the moment. There are a lot of things specialized for the certain countries, but you cannot generalize. There's only one thing which is mentioned just for entertainment. You know, Corona is the emotional stress on everyone. Say there's one emirate in the United Arab Emirates who reduced by 50% the fines for any traffic violence before end of June. And it's called tax measurement in relation to Corona. Why ever? And that's my overpoint. And now Łukasz is going to the details and to the technical points. Thank you.
Well, thank you very much, Alexander, for this introduction. During my presentation, I will focus on the general measures concerning taxation. I mean, tax reliefs concerning the level of collection of taxes. And can I have this presentation, because I can't move it? And my presentation will come in a second. Okay, so referring to the first point of my presentation. Thank you, Martí, very much. And this is yes, okay, sorry, we get some problems with presentation. Have it right now. The application of tax relief regarding collection of taxes during COVID-19 outbreak. So this is the general topic that I would like to focus on during this short presentation, and would like to focus on the approach taken by the national governments towards granting this kind of reliefs. Unlike at the presentation of Alexander, we focus on the level of collection taxes, which constitute, based on this research, quite important part of tax measures implemented in order to fight with the situation caused by COVID-19. And what kind of new measures implemented in connection with COVID-19 we have? The most important ones, which are used by most of the countries, are extension of statutory deadlines for payment of taxes and filing tax returns, redemption of outstanding tax liabilities, penalties, interest, deferral of tax payments, tax exemptions, suspension of tax proceedings, and last but not least, all these measures, or the bigger part of this, should be applied in line with the EU stated regulations, which is also very important. And many EU countries had first to obtain approval from the EU Commission to apply such tax measures in order to help to the businesses. And we have applicability of new measures. It's very difficult to provide you with the universal model that has been applied by all the countries. So depending on the country, depending on the budget situation and the COVID impact, there are applicable these measures to all taxpayers versus particular groups of taxpayers. Some of them relates only to SMEs, enterprises, some of them large enterprises, most affected sectors, or even self-employed. And some of them covers all types of taxes, and some not. They refer only to the particular taxes. For example, in Poland, we do not have a general measure applicable to all taxes. For example, like in case of VAT, we do not have any deadlines. We do not have any deferral of payments. Yes, and duration of new measures. The issue is whether they are short-term or long-term measures. I mean, the most important thing here, at least in my opinion, to strike a balance between the benefits that should be provided to the taxpayer in order to enable them to operate businesses simply, and the necessity of the needs of the state budgets. Yes, so I think that we may say that the short term may not be as beneficial as they may appear, because after this short term period, for example, taxes should be paid. No one knows what will happen in a few months regarding the COVID and the profitability of the business. So in some cases, the deferral of the payments of the taxes for a short term may result in lack of cash flow and lack of liquidity for the businesses during a month or two. So probably, at least from that perspective, the long-term measures can be better for the taxpayers and businesses. Extension of statutory deadlines, it's usually introduced by operation of law, and there is no taxpayer request necessary, just because in order to facilitate the taxpayers to operate the businesses and simply save the workforce, refrain from laying off workers. So that's the most important thing. In most cases, they are obliged to apply for such extension. Yes, they should apply by operation of law without any actions from the taxpayers. Extension period also differs from in different countries. For example, we have 1.5 months in Belgium for filings CIT returns, 3 months Poland and Czech Republic for annual tax returns, up even to 6 months in Belgium. So It really depends on particular countries. Usually, such extension of statutory deadlines, especially concerning the formal requirements, not the payments, is connected with an obligation to settle annual tax return and submit annual tax returns. So these are one of the most important factors, because during the COVID, there were absence of or limited human resources even necessary for preparation of such simple thing as tax filings or tax reports. And extension of statutory deadlines refers also to other remaining taxes which are not settled on an annual basis, and also other documentation reports, such, for example, in Poland, transfer pricing documentation or MDR information. The deadlines for providing this kind of information has also been extended. Deferral of tax payment, which is definitely aimed at improving cash flow position of the taxpayers, is very popular. I think most of the countries have implemented this kind of measure, and it's usually applicable to payments in installments or suspension, and it's really applied in many jurisdictions. And what is the most important and most interesting thing here is that deferral of payments is usually without interest or prolongation fees. And that's why this kind of measure is treated as a state aid measure, yes, because it's given to the taxpayers without any payment for that, which means it favors certain taxpayers, yes, which really makes sense, yes, because this is could be a real relief, authentic relief for the countries. This deferral without interest or any other fees can be seen in Czech Republic, Croatia, Poland, or Spain. We have also in certain cases some special instruments which are not very popular, like, for example, interest-free tax loan in Lithuania, which is a special instrument applied in order to defer payment of the taxes. Redemption of taxes and penalties or interest, and based on the research, it is usually applicable in case of interest for delay, penalties, and similar payments. What is important, it is not applicable to the tax liabilities, yes, because as I understand, the government would like to first give the chance the taxpayer to pay taxes, not to redeem the taxes, yes, because that's obvious, at least from the state budget perspective. This kind of measures are applied automatically, like in Malta or Romania, or at the taxpayer's request, and which is dealt on a case-by-case basis. Penalty for late filing, like in Ireland or in Finland, which is subject to the tax authority's approval. And as I mentioned, it's rarely applied in case of outstanding. Like in Poland, we have a special guidance given by the Ministry of Finance, when they suggest that, first of all, the tax authorities should focus on granting extension and deferrals, not redemption, which is not surprising. Now, we have the next slide is about suspension of tax proceedings, which is also a measure maybe not really connected with collection of the taxes, but which is implemented in order to facilitate the taxpayers really to carry on businesses during the COVID era. Yes, like suspension of deadlines for filing complaints, appeals document to the tax authorities. In Poland, we have like 2 months of this kind of holidays. It is also very good for the taxpayer and for the whole businesses, yes, because the main goal of implementing of this measure was to give the taxpayer enough time to prepare for COVID, to prepare themselves and the businesses without necessity to taking care about the tax inspections, tax control, which at least in Poland can be very burdensome and troublesome. Yes, and this is recognized by the taxpayers as a real relief, not pecuniary, but very, very important for the businesses. We got also some measures concerning suspension of debt recovery, like in Greece. They have suspension of tax debt collection until the end of August. Like in Hungary, the suspension is from 24th March until the 15th day following the end of an emergency situation, which is also helpful for the businesses. And the last thing, we got application of old measures available for the taxpayers before COVID-19, like in Poland, we got a full range of tax reliefs that could be applied before the COVID and can be applied during the COVID era. The most important features are that we have the relaxation of conditions by national tax authorities, special guidance provided to tax authorities regarding the approach towards the taxpayer's application for relief. For example, in certain situations, the tax authorities should not ask the taxpayer for presenting financial data in order to grant the relief, which is also very helpful for the businesses. Conditions for application of the relief, the taxpayer's important interest and public interest. We have wide interpretation of those definitions, especially in relation to COVID-19 situation, and refraining from initiating tax proceedings in case of taxpayer applying for the relief, because the practice was that you are applying for the relief, you have a tax inspection to check whether you really need that relief. Right now, in the COVID times, the tax authorities should not initiate tax proceedings in case of taxpayer applying for a relief. That was the presentation in a nutshell. Daniel, the floor is yours.
Thank you, Łukasz.
Thank you, Martí. Welcome to the next topic. It's regarding tax issues associated with the recapitalization of companies. So we are actually talking about, I would say, mid-term to long-term measures. We have heard interesting things about short-term measures. We have, of course, different forms of recapitalization and their tax consequences in Switzerland and other countries, contributions in cash or in kind, forgiveness of loans, subordination of agreements, corporate restructurings, mergers, spin-offs, carve-outs, and a lot of things. We would like to focus here on short, not so much on short, but on middle and long-term measures. And this helps us to see what happens maybe, hopefully, after the COVID-19 crisis. One of the most important matters is the tax loss carry forwards, and also maybe certain carry back losses, which may also be available. The recapitalization of companies is indeed an old topic, but it has become obviously a hot topic nowadays due to the reasons we are all aware of. Is it really the same old tax issues, or is it are there maybe some tax reforms in sight in favor of companies? We have heard a lot about short-term measures and good measures to save the liquidity. Now, with respect to the countries, I think the issues I'm going to talk about are general issues which are applicable in most countries, or almost in all of the countries, but in a different way. The basis of my presentation is Switzerland, and there are a number of other countries which are covered by the other panelists, or also other members of the UIA Tax Commission. What are typical tax issues arising for companies in distress? As I said, it's the short-term issues, short-term measures we have heard about just before. Łukasz and Alexander have talked about certain very important measures to make sure that we can get rid of liquidity problems, to solve them in the next months. As I said, we focus on mid and long-term issues. And one of the central issues is the utilization of tax loss carry-forwards and or carrybacks. So the NOLs, or tax assets, or tax attributes, as the Americans say. So what is carrybacks? Well, that would be offsetting of losses of the current year against the profits of the previous tax year. Obviously, most companies had a good 2019, or a lot of companies had a good 2019, but 2020 is bad. So it would of course be good if we had the possibility to reduce the taxes of the previous year. And some countries offer that. I think Poland is one of those countries. And the question arises whether countries that do not offer that, they do not provide that in their tax laws, whether they might accept a tax provision or a tax effective provision which provides for possible future expenses, but which have been caused by the COVID-19. As the name says, I mean, it's COVID-19, and it started obviously in the year 2019. Some tax authorities argue, well, sorry, we cannot grant that retroactively, but the respective loss will be incurred in 2020, but then we may suffer losses, and would be good to have a retroactive effect. So that's something to focus on. And in Switzerland, they're still discussing whether, to a certain extent, such a provision may be booked in the accounts and has a retroactive effect. Then another measure which would be very interesting would be an extension of the statute of limitation, if there is one. In a number of countries, there is a statute of limitation for tax loss carry forwards, meaning that after a certain period of years, in Switzerland it's 7 years, it's over and you cannot use them anymore. There is no plan in Switzerland, at least, to extend the statute of limitation for the reasons of COVID, but it's possible that certain measures may nevertheless benefit from an extension. So recapitalization measures is mainly an elimination or a reduction of an existing undercapitalization or even an over-indebtedness, which is worse, obviously. So if liabilities are higher than assets, then we have an over-indebtedness. And undercapitalization just means, okay, the capital is lower than it should be, as it has been originally. And ideally, in the situation of a recapitalization, we should try to get a sustainable improvement of the equity basis for a hopefully more prosperous future. But that's, I think, a luxury problem, and it would be good to do that. And most companies just fix the current situation, and at least, I mean, it's already good if they can do that. So one option is to increase the capital to the previous capitalization level, so what we had before the crisis. Another option is to go beyond that. As we said, it's the luxury version, that we could say, well, I think the equity we have seen is not good enough, and we should go beyond that and increase the capital. Of course, that has certain tax consequences for the future, but it may help us from an economic point of view. Then what is very frequent, what we see in most recapitalization situation, is a forgiveness of shareholder loans. So forgiveness of loan, waiver of loan, that can be associated and combined with third-party waivers of debts. So if creditors do the same, third-party creditors. And another possibility is, I would say the weakest one is, well, weakest one, or maybe the more creative one, if we want, is just corporate and restructuring reorganizations. So that would not just re-establish the current situation, but it would change something in the structure. And well, you are probably all familiar with these reorganizations. Nothing new really, but it's becoming new and interesting maybe in a situation of a company in distress. It's the merger with another group company, for instance. A loss-making company is merging into a profitable company. They can combine their operations. Another thing is, well, we see that the business is bad, this company is in a situation of distress, and then we separate it, we perform a spin-off and sell maybe the business to a third-party buyer. Then alternatively, instead of a spin-off, it's a sale of assets or a sale of a business unit of certain selected assets is also possible. And last but not least, and this is not really a recapitalization of a company, but it means window dressing. It's a revaluation of assets there where the book, as you know, the book values are very low and can then be revalued to a fair market value. And that may have the impact that the losses disappear. What are possible issues related, resulting from recapitalization? Hopefully, what we would like to achieve is tax neutrality of recapitalization measures. We would hope that there is no impact on taxable profit, or meaning that there is no increase of the taxable profit and that tax loss carry forwards can still be used. And then besides the continuity or the full partial loss of existing tax loss carry forwards, would like, of course, to create new possibilities to reduce taxes if this is possible. But this is related to income taxes, to corporate income taxes. There are also other taxes. It's a VAT, as has already been mentioned by Alexander, in connection with the short-term measures. But what is also very bad, of course, is if recapitalization measures have an impact on input VAT. For instance, that input VAT is reduced because of such measures. That would be bad, of course, and should be avoided. In Switzerland, we have a stamp tax on the contribution of capital. In the situation of a recapitalization of a company, there is an exemption up to 10 million Swiss francs and maybe a waiver or partial waiver if the amount goes beyond 10 million Swiss francs. Then, of course, the question of whether the statute of limitation can be extended, but beyond the 7 years we have, for instance, Switzerland. Additional tax issues and tax planning opportunities are, for instance, that we do a sale or a partial sale of a business, as we have mentioned before, an asset deal or a share deal. What is better? An asset deal may have the impact that silent reserves and goodwill and other intangibles are realized and eating up, reducing tax loss carry forwards, which is maybe something we really want, because a possible buyer can get a step up in basis. Another possibility, another measure could be to make dividend distributions or to provide loans by strong subsidiaries, healthy subsidiaries, to its suffering parent company which is in distress. So dividends, however, often are exempt from taxation in many jurisdictions. There's a participation relief or a participation exemption. In Switzerland, there is a system of participation relief where dividends are, in the first step, taxable, but where a deduction, a reduction is granted for such dividends. And if you pay a dividend to a loss-making company, it's like a loss of tax-free income and should be avoided. So usually upstream loans, also providing certain liquidity, are preferable. Then another question is injection of new capital or forgiveness of loan. As we said before, there are different possibilities which are available. An injection of new capital, well, should be neutral normally, at least in Switzerland. In this case, it's just, to increase the share capital, or maybe with a share premium. The forgiveness of loan, however, might be taxable or might have a negative impact on tax loss carry forwards. So this analysis must be made in order not to lose losses, or not to create taxable income. Another possibility is the subordination of loans, subordination agreements. That's very often one of the first measures which is taken. Because, for instance, in Switzerland, if a company is over-indebted, it should go to the judge and they should start the liquidation of the company, bankruptcy. That's, of course, not something we want. And during the COVID-19 crisis in 2020, the Swiss company law was changed in such a way that the respective company does not need, or the board of directors do not need to go to the judge immediately, but may take their time. But once they have to go to the judge and have to deposit the balance sheet, of course, before that happens, a subordination agreement with respect to shareholder loans is much better, is preferable. But of course, it's not a sustainable measure. And usually we say that it should not last for more than 1 to 2 years. Of course, we see companies where this goes on for many years because they have a very strong parent company. But the client and the board of directors have to take a decision about the respective measure, and they should always take into account the respective tax consequences. So what are our takeaways with respect to the recapitalization of companies? First of all, as far as I could see, is that basically in most countries I have seen, there are no special rules now with respect to recapitalization of the company, but there are a lot of rules for short-term measures to reduce liquidity problems of a company in order not to create new tax problems, let's say in 2020 or maybe in the following year. So that, which is very good and which is very much appreciated if that happens. It does not lead to bankruptcy immediately. Nevertheless, we have to probably, our clients, the companies have to find measures to recapitalize their companies when they see, that there is no bankruptcy proceedings going on, the company has a chance to survive. And then this requires a very careful analysis of risks and opportunities from a corporate and of course also from a tax point of view. Now, we hope at least and would expect that the tax practice of the tax administration should be more favorable than it used to be previously prior to the COVID-19 crisis, in order also for the state to avoid more expensive rescue measures, because usually it's more expensive for the state to rescue important and big companies. It's more effective than to be more generous with respect to tax measures and to accept maybe a tax-free recapitalization or to accept a waiver. The improvement of short-term measures we heard regarding liquidity and insolvency should be quite good, as far as I heard in many countries, and that's not a part of the, it's not part of the topic of mid and long-term measures. But as important as before, or even more important in my view, is tax planning has become very important, even more important than before, and constant monitoring of the general tax situation of a company is a must for the board of directors. So the board of directors, you know, they are challenged, obviously, and I think they're also challenged by taxes. So thank you very much for your attention.
Thank you very much, Daniel. We will now hand it over to Marilyn, who will talk about broader issues such as the impact of COVID-19 on the administration of justice. Over to you, Marilyn.
Thank you, Martí. And as you say, I'm going to be looking at some more general issues around access to justice with specific reference to the resolution of disputes between taxpayers and the tax authority. And although I'm going to be referring mainly to the UK experience, this has been built on things that were happening anyway, and perhaps shows the direction that litigation is going generally and how these things will be managed in the future. Now, in the UK, we have specialist tribunals which are part of the tax system, and one of those specialist tribunals deals solely with tax disputes. So it is always between the taxpayer, who may be everyone from an unrepresented plumber or individual to a multinational company, and they are taking their complaint against our tax authority to court. Now, of course, I discovered that you know, COVID-19 has had a huge impact on court hearing-based resolution of disputes. But it hasn't necessarily affected all countries. I mean, I learnt today that in Spain, tax litigation is conducted by written submissions. So COVID-19 has no impact there. In the UK, it did. And as soon as lockdown was announced, all face-to-face hearings in the courts were cancelled. Well, all the ones that had been listed were cancelled, and most also there are strict time limits for when parties have to do certain things, and there was a general extension of those time limits so that parties would not lose their rights simply because they couldn't, for practical reasons, being isolated, couldn't get to the papers and so on, they wouldn't lose their right to conduct their litigation. So what happened next? Well, the work of the tribunal never stopped. Before COVID-19, there was a trial going on of holding hearings by video link. And it was pretty rudimentary, it has to be said, and the technology failed in about 1/3 of cases. But rather like medical advances in wartime, the experience of COVID-19 meant that video technology developed at an exponential rate and has become very effective, even for large-scale hearings with lots of parties. So, for example, the tribunal now has its own video platform with a team of people doing the tech in the background. When it started, there could only be 4 participants. So that might be in addition to the judge. So that would be, you know, 1 taxpayer plus their representatives if they had them. We can now accommodate well over 20 participants, which allows for observers, witnesses, and so on. And that is likely to increase in future. Where video hearings weren't possible, there have been a number of telephone hearings, which obviously are limited in what you can do, because if you've got witnesses, for example, you can't have witnesses giving evidence over the phone. You need to see the whites of their eyes. And there's always been the ability for basic, straightforward cases to be dealt with just by written submissions. And the category of cases that can be dealt with in that way has been expanded so that there are more cases going through just being dealt with on the papers, as it's called. And although there's been quite a lot of resistance actually among participants, both HMRC and the taxpayers, to having video hearings. But it's not up to them. The tribunal does ask for their views, but it comes down to the decision of the judge whether it's suitable for a video hearing, a telephone hearing, a paper hearing, or whether it does have to be postponed until the courts are open again. Now, unsurprisingly, a number of issues, both technical and practical, have arisen, and how do we deal with that? I mean, one thing is, how do people make appeals? All the staff at the administrative centre were working from home or not working at all. So where taxpayers were sending in their appeals on paper forms, they were just forming a nice heap in the office. But for about a year now, it's been possible to make appeals online. And that was indeed the way in which taxpayers were being encouraged to take their appeals. And so those come straight through and can be dealt with, can be processed by people working remotely. So it enabled, I mean, there's been a slowdown in the processing, but it works, it can still go ahead and happen. Us judges need training. We don't know, you know, some people had participated in the video trial, but there's been a program of training for the judges. The video hearing team are always on hand. And of course, you've got the appellants themselves and indeed the representatives, the lawyers who are representing clients. They need training on how all this works as well. And it's particularly acute for the unrepresented taxpayer, who forms a large proportion of the people who come to the tribunal. They don't have any lawyers or accountants helping them. They just feel that it's not right, it's not fair, and they want to have their say. And there has been a lot of work gone into providing information online. There have been little videos about how things work. We've just produced a video of a mock video hearing. So we've got a video of a video hearing, which shows the participants or prospective participants what is expected of them, what to do, how they can, you know, how they will be able to put their case. I mean, of course, there's also, have people got adequate equipment? Is your broadband fast enough? Have you got an adequate Wi-Fi link, which isn't always the case. It never ceases to amaze me that in the middle of China or Guatemala, you get a strong signal, and there are parts of Devon and Cornwall in England where you've absolutely no hope of getting anything at all. But again, that is something, so there are some judges, for example, who can't hear cases, so that limits the number of cases that can be heard, simply because they're living in a part of the country where they do not have a reliable enough infrastructure to do the hearings. There have also been, I mean, one of the things that are done is that there are tests done with all the participants and the judge beforehand to check that everybody can connect to the platform, that everybody has got a strong enough signal, and so hopefully it will be all right on the night. And although there have been some fairly spectacular fails, by and large it's worked pretty well. There's also been issues with HMRC because they normally produce all the paperwork for the hearings, all the documents and the letters and arguments that everybody's going to rely on. And they're all working at home. And we've now, well, a lot of adaptations have to be made so they could produce digital versions of all these documents so that all parties can look at them. And this leads on really to the two ethical issues that I just want to touch on. One being about access to justice, and the other open justice. Justice must not only be done, it must be seen to be done. So when it comes to access to justice, as I say, a lot of taxpayers, inexperienced, they may be quite poor. Have they got, you need two screens because you need one screen to see the proceedings, you need another screen to see all the documents. Have they got that? Have they got a quiet room where they can be uninterrupted and so on? Do they speak English? If not, then the court can provide an interpreter, and we have had video hearings with interpreters involved. And again, the issue of, well, what are they supposed to do? We've tried to address by the online help and videos and so on. And again, it's a principle in the UK that all hearings are in public. Well, you can't have a telephone hearing or a video hearing with 4 participants in public. So that did require secondary legislation to authorise the making of orders to hold hearings in private. But now that the video platform is moving, you can accommodate 20+ participants, it is now possible for the press, or indeed members of the public who are interested, to apply to be able to observe the hearing. And if the space isn't needed for the participants, that would usually be granted. And also third parties, the press, the public, can apply for a transcript of any hearing. It's automatically audio recorded, not video recorded, but audio recorded. Or they can go along to a court building and listen to the hearing. So there's been quite a lot of movement towards the openness and preserving that access to justice. And the experience so far has been very positive. And I think it's the way that remote hearings seem to be the way it's going to go in the future, COVID or no COVID, because I don't know what's been happening in other countries, but there has been a reduction in court buildings, for example. So it's more difficult for people to get to a physical hearing. And with this very rapid development of the technology, large hearings with multiple witnesses, cross-examinations, interpreters, all this is becoming very possible, and indeed saves a lot of time and money because everybody can participate from wherever they are. So in a way, COVID has been a good thing for the administration of justice in the UK, and that it's accelerated these moves towards new and perhaps better ways of doing things. I mean, I'd be interested if anyone has any comments on how things have worked in their countries. That's really all I wanted to say about the UK experience.
Okay, thank you, Marilyn. From Spain, I mean, it's not related to the administration of justice, but one thing that happened because of COVID-19 is that before the crisis started, the Spanish revenue had launched a program, was like a trial program to carry out tax audits by video conferencing. And as a result of the crisis, this thing has completely sped up, has accelerated completely. And actually, some weeks ago, the Spanish government passed new regulations to establish the rules by which tax audits now can be carried out by video conferencing. So, I mean, it's not administration of law, but it's the application of this new technology to tax management of taxpayers. Okay, thank you very much, Marilyn. Well, as promised, now we are happy to take questions from the floor. We have at least one question, so we are grateful for that. The question goes: during pandemic, scarcity of goods may be a bigger issue to be addressed. Is not the tax hike or higher tax a tool to regulate demand? Alexander, you talk about VAT. Maybe you want to address this question, or?
Yeah, I can. I thought about a little bit about that. I think one idea sounds good, because if you increase the tax on special goods, which are rare at the moment, the one gets a good who can do the most thing, and he's prepared to pay the highest price. On the other hand, we have a lot of disruption in the economic process, and if you increase that by, let's say, changing the market by measurements like that, you might cause even more trouble as we have at the moment. So I think it's, in a more stable situation, you might think it's good, but in a stress situation like we have now, I think it's better to increase everything which happens in the economy and not to try to stop it or to reduce it. And on the other hand, you know, if the state takes measurements into the economy with a certain goal, usually they are too late to do it the wrong way or to do too much. I think the problems caused by measurements like that are higher than the real problem with, let's say, scarcity of some goods delivered from China or other isolated countries at the moment.
Okay, the only thing I would like to add also is that, at least based on the experience that we have in Spain, if the government intends to change, for instance, VAT for a specific sector, either upwards or downwards, the government has to be ready to receive incredibly political pressure from other sectors. I mean, if you improve the position of one sector, then you will have a row of representatives from 100 other sectors saying, no, I'm also a very strategic sector. I also want my VAT down, for instance. So yeah. At least based on the experience we have in Spain, governments are really reluctant to changes in indirect taxation because of all these side effects. Okay, I don't know if there is any other issue. If not, as a final remark to Daniel's presentation, I would only mention that in Spain, we have the so-called Capitalization Reserve. This is a reserve that can apply any corporate income taxpayer, which allows the taxpayer to reduce the tax base by 10% of the increase in equity of every year. This is limited to 10% of the tax base. And this is contingent to maintenance of this increased equity for 5 years. But I do think that this is one of the good measures that we have in Spain regarding corporate taxation. And for small and medium-sized companies, we have an additional reserve, which is called a loss labeling reserve, that allows, again, 10% reduction of the tax base in anticipation of future losses. If in a 5-year time losses do not occur, then the company has to recapture the reduction applied. But at the end of the day, I mean, it's like a 5-year revolving system. And if you can combine both provisions, you can reduce your effective tax rate, or your tax rate, from the statutory 25% to 20%. So these are measures that really help to keep companies capitalized. Okay, I don't know if there are more questions. If not, well, we do hope that you found this discussion interesting enough, and we'll see what the post-COVID-19 era will bring us tax-wise. Before we finish, I would like to thank all of you for attending this webinar. Special thanks to the speakers for their presentation. And last but not least, also special thanks to the UIA staff for their support and help in organizing this seminar. And obviously a special mention to Colette Sourin for making sure that everything worked smoothly. So thank you very much to all of you, and stay safe. Take care.
Thank
Thank
you.
you very much. Bye.
Bye-bye.
Bye. Thank you.
Bye.